Welcome to Mumbai Law Study. Let's test your company law knowledge with 40 important multiple choice questions. Listen carefully to each question and its options. Let's begin. Topic 1, Meaning and definition of company. Question 1, under the Companies Act 2013, a company means option A partnership registered under the Partnership Act. Option B, a company incorporated under the Companies Act or any previous company law. Option C, any business organization. Or option D, a sole proprietorship. And the answer is a company incorporated under the Companies Act or any previous company law. Question 2. A company has a legal personality. Option A, identical to its members. Option B, separate from its members. Option C, dependent on its directors. Or option D, dependent on its shareholders. And the answer is B, separate from its members. Question 3. Which case established the principle of separate legal personality? Option A, Foss vs. Herbotel. Option B, Salomon vs. Salomon and Company Limited. Option C, Ashbury Railway vs. Rich. Or option D, Royal British Bank vs. Turquoise. And the answer is option B, Salomon vs. Salomon and Company Limited. Question 4. Perpetual succession means. Option A, company exists only during the life of directors. Option B, company continue despite death or insolvency of members. Option C, company must be renewed every year. Or option D, company ends when shares are transferred. And the answer is option B. Company continues despite death or insolvency of members. Question 5. Which of the following is not a characteristic of a company? Option A, separate legal entity. Option B, perpetual succession. Option C, unlimited liability in every case. Or option D, official legal person. And the answer is C, unlimited liability in every case. Topic 2, Incorporation of Company. Question 6. Incorporation of a company results in option A, creation of a separate legal entity. Option B, dissolution of the company. Option C, automatic winding up. Or option D, formation of partnership. And the answer is option A, creation of a separate legal entity. Question 7. Which authority is primarily responsible for registration or incorporation of companies? Option A, RBI. Option B, Registrar of Companies. Option C, SEBI. Or option D, Income Tax Department. And the answer is option B, Registrar of Companies. Question 8. The certificate issued after registration of a company is called option A, Certificate of Commencement. Option B, Certificate of Incorporation. Option C, Certificate of Transfer. Or option D, Certificate of Ownership. And the answer is option B, Certificate of Incorporation. Question 9. The date mentioned in the certificate of incorporation is generally treated as option A, date of commencement of winding up. Option B, date of birth of the company. Option C, date of first AGM. Or option D, date of first dividend. And the answer is date of birth of the company. Question 10. A promoter primarily takes steps for option A, winding up the company. Option B, formation and incorporation of the company. Option C, conducting criminal trials. Or option D, appointment of judges. And the answer is formation and incorporation of the company. Question 1. A pre-incorporation contract is entered into option A, after incorporation. Option B, before incorporation of the company. Option C, after winding up. Option D, during liquidation only. And the answer is before incorporation of the company. Question 12. Which document is fundamental to the incorporation of a company? A. Memorandum of Association. Option B, partnership deed. Option C, sale agreement. Or option D, employment contract. And the answer is option A, Memorandum of Association. Topic 3. Memorandum of Association. Question 13. The Memorandum of Association is commonly known as option A, internal rule book. Option B, charter of the company. Option C, annual report. Option D, audit report. And the answer is B, charter of the company. Question 14. Which clause of MOA specifies the name of the company? Option A, object clause. Option B, name clause. Option C, capital clause. Option D, liability clause. And the answer is option B, name clause. Question 15. Which clause specifies the register office date of the company? Option A, registered office clause. Option B, object clause. Option C, capital clause. Option D, liability clause. Answer is option A, registered office clause. Question 16. The object clause of MOA specifies option A, names of employees. Option B, objects and purposes of the company. Option C, salary of directors. Option D, date of AGM. And the answer is option B, objects and purposes of the company. Question 17. Which clause specifies the liability of members? Option A, name clause. Option B, object clause. Option C, liability clause. Or option D, capital clause. And the answer is option C, liability clause. Question 18. The capital clause generally states option A, authorized share capital. Option B, salaries of employees. Option C, number of directors. Or option D, number of auditors. And the answer is option A, authorized share capital. Question 19. The MOA primarily defines option A, internal management only. Option B, scope and powers of the company. Option C, personal affairs of members. Or option D, employment conditions. And the answer is option B, Scope and power of the company. Question 20. The contents of the MOA are governed by option A, a Companies Act 2013, option B, Indian Contract Act only, option C, Transfer of Property Act, or option D, Evidence Act. And the answer is answer A, Companies Act 2013. Topic 4, Doctrine of Ultravirus. Question 21. The term ultravirus means option A, within the powers, option B, beyond the powers, option C, equal powers, option D, delegated powers. And the answer is option B, beyond the powers. Question 22. The doctrine of ultravirus primarily related to option A, objects of the company, option B, appointment of employees, option C, personal property, option D, criminal procedure. And the answer is option A, object of the company. Question 23. An act that is ultra vires, the company is generally option A, valid, option B, void, option C, voidable at the option of directors, option D, automatically ratified. The answer is B, void. Question 24. The leading case on the doctrine of ultravirus is Salomon versus Salomon, Ashbury Railway Carriage and Iron Company Limited versus Reach, Foss versus Harbutel, or option D, Turcon's case. And the answer is option B, Ashbury Railway Carriage and Iron Company Limited versus Reach. Question 25. An ultra-virus act can generally be ratified by option A, shareholders, option B, directors, option B, employees, or option D, creditors. And the answer is no, if it is ultra-virus, the company itself. Important note, an act beyond the company's object cannot be validated merely by shareholder approval. Question 26. The main purpose of the doctrine of ultravirus is to option A, protect the company and its member, option B, increase directors' salaries, option C, reduce taxation, option D, appoint auditors. And the answer is protect the company and its members. Topic 5. Articles of Association. Question 24. Articles of Association primarily deal with option A, external objects of company, option B, internal management of company, option C, criminal law, or option D, taxation. And answer is option B, internal management of company. Question number 28. Which document contains rules and regulations for internal management? Option A, MOA, option B, AOA, option C, prospectus, or option D, certificate of incorporation. And the answer is option B, AOA, article of association. Question 29. The AOA is subordinate to option A, MOA, option B, prospectus, option C, board resolution, or option D, employment contract. And the answer is A, MOA. Question 30. If there is a conflict between MOA and AOA, option A, AOA prevails, option B, MOA prevails, option C, both become void, or option D, directors decide. And the answer is answer B, MOA prevails. Question 23. The articles of association can generally be altered by question 1. Ordinary resolution in all cases. Option B, special resolution. Option C, court order only. Or option D, auditor's approval. And the answer is answer B, special resolution. Topic 6. Doctrine of Constructive Notice. Question 32. The doctrine of constructive notice applies mainly to option A. Public documents of the company. Option B. Private diaries of the directors. Option C. Personal bank accounts. Option D. Employee records. And the answer is option A. Public documents of the company. Question 33. Under constructive notice, outsiders are presumed to know option A. Internal discussion, option B. Contents of public documents such as MOA and AOA, option C. Directors' private communications, or option D. Employees' personal information. And the answer is contents of public documents such as a MOA and AOA. Question 34. The doctrine of constructive notice generally operates in favor of option A. Outsiders, option B. Company, option C. Employees, or option D. Creditors only. And the answer is company, option B. Question 35. Constructive notice is based on the assumption that option A. Public documents are available for inspection. Option B. Directors know everything. Option C. Members know all company affairs. Or option D. Employees control of the company. Answer A. Public documents are available for inspection. Topic 7. Doctrine of Indoor Management. Question 36. The doctrine of indoor management is also known as option A. Turquoise rule. Option B. Salomon rule. Option C. Force rule. Option D. Rich rule. Answer is Turquoise rule. Option A. Question 37. The leading case establishing indoor management is option A. Salomon versus Salomon. Option B. Royal British Bank versus Turquoise. Option C. Ashbury Railway versus Rich. Option D. Force versus Harbortel. And the answer is Royal British Bank versus Turquoise. Question 38. The doctrine of indoor management protects option A. Outsiders dealing with the company. Option B. Directors only. Option C. Auditors only. Or option D. Government officers. And the answer is outsider dealing with the company. Question 39. Under the doctrine of indoor management, an outsider can generally assume that option E. Internal procedures have been properly followed. Option B. Company has no directors. Option C. MOA is invalid. Or option D. Company has been dissolved. Answer is option A. Internal procedures have been properly followed. Question 40. Which of the following is an exception to the doctrine of indoor management? Option A. Knowledge or irregularity. Option B. Perpetual succession. Option C. Separate legal personality. Or option D. Limited liability. And the answer is knowledge or irregularity, option A. If you like video and if you think it is useful, so please like, share and subscribe. Thank you.